So we've got Ingrid Fernandez, who is a legal expert. There you go. It says it right there on the screen. She is an actual lawyer, whereas I'm Steve Folland. I'm the host of the Being Freelance podcast and run the community. Ingrid is in the community and was like, Steve, have you done anything about AI and freelance stuff? I was like, no, which is what we're going to address today. So basically, if you've got a freelance business and in any way are using AI, it could be tripping you up, could be tripping all of us up in ways maybe we hadn't considered. So we're going to crack on since we started a little bit late. Ingrid sent me an amazing list of 5 ways AI could be tripping us up. They're on the screen right now. Everything from the way we might be delivering work to our clients to maybe our clients giving us AI stuff. But let's start at the very beginning because it's a very good place to start, which is why it now says question 2. Question 1. Are we putting our clients' personal information in AI? Do we need to define AI? Like, is this because AI seems to be in everything?
It is in everything. It's in a lot of the tools that we use, probably without realizing. It's sometimes on the back end of things that we might not know it's being used in that way. But the way I wanted to talk about it today is more when we're actively using AI. So that might be Claude, Gemini, ChatGPT, Perplexity, any of the big LLMs that we see, we hear about. It's more, we could go deeper, and I'm happy to chat about when the tools we use AI, but this is more about the first gate we go through is if we're using it ourselves with our clients and the people we work with.
Nice. All right then. So, are we putting our clients' personal information in AI? What could we be doing wrong then?
So there are a couple of things that come up with this. Firstly is if we're doing it, are we allowed to do it? So that's when we have to go back to our trusty privacy policy, hopefully, which everyone obviously has and keeps updated every few months when they change their tools. But this is when it really does become relevant because we should be disclosing to people all the tools that touch their personal information. So, for example, Steve, if you and I work together, it may be that Google Workspace touches your personal information because your email comes to there. And it may be that we have a Zoom call together, so Zoom touches your personal information. And then if I was going to share some of the work that we do together with AI to brainstorm with it or to problem solve with it, I need to be transparent with you about what I'm sharing with AI about you. So that's the first layer, the transparency part. And then the second layer is there's obviously a lot of opacity,
Hang on, I'll
around
ask
how
Claude.
these
No, go on.
because Claude will be very clear. There is that opacity around what happens within these LLMs, and I don't pretend to know. I'm not an expert on how they intricately work. But when we're feeding personal information about the people we work with and the people who may be our clients or potential clients, we don't really have a lot of visibility over what's happening to that information. So we can put controls in place that limit whether those LLMs use that personal information to train itself, and we all should be doing that. But beyond that, there's just a lot of fog really around what happens. And this isn't to scaremonger anyone, but it's that we just don't really understand how these things work and what they do with the data that they get. So I think this is really about first transparency and then really making a discerning choice about whether you need to be sharing personal information that you're getting from clients or potential clients with AI. And if there's any way you can do what you do for them without doing that, because when I like to think of personal information as something quite valuable that people are sharing with us in doing business together. And so when we're given something valuable, we have a responsibility to take care of it. So I think if I'm putting something valuable into this LLM that I don't really understand what it's doing, I don't know what's going to happen to that valuable thing I've been trusted with. So it's really taking care of what we've been given.
And when we're talking about personal information, that could be what?
So your name, so Steve, and your email address. It can be personal details like your address, your business address, your company business number. Then it can get a little more in depending on the services that you do for someone. They could be the notes you take from the meetings that you have together, and that could have information about what kind of business they run, where they're at in their business, what challenges they're having in their business. You could have access to financial information about that company. It can really range. A lot of the personal information that we come across in business might seem like business information when we're talking about it, but underneath it, we could identify someone's business, where they live, how they work, how well their business is doing, how much they're earning, a whole lot of information about them from that.
So is the answer simply that this is hidden away in a privacy policy on our website? Or like is it enough that I at the beginning of that Zoom call or Google Meet call go, "Oh, do you mind if I take some notes?" Or Gemini takes some notes. Like how should we be approaching it?
Well, I think I'm a boring lawyer, so I'm always going to say your privacy policies should have all these details hidden away in them. But on a more practical level, absolutely transparency should be involved in our conversations with our clients. So if you're having an AI note taker monitoring your calls, you should definitely just advise them and give them really the option to opt out. And this is something that we kind of talked about back in 2018 when GDPR came around, and we were talking about personal information then and giving people a choice. And really, we want to be doing that again. It's not, again, I'm not at all demonizing AI or saying people shouldn't use it, but I think we should be giving each other the choice of how we interact with it. And some people have a really strong position on that. Some people are really open to it. So I think when you get on a call and if you're going to have an AI note taker, give people the option to participate or not in that note taker. And if, for example, you use AI, and we'll come to this in a little bit, in how you provide the services, let people know that it's one of the tools in your business, and they might have a say in how their personal information goes into it. So it's that transparency piece. If we can be open and make it a conversation, then I think that's the best way forward.
Nice. Anthony. Hey, Anthony says opacity. Okay, good.
Thank you.
I'm
Should
glad
have checked that word before I said it.
All right, should we move on to question two? Or
Sure.
point two, really. So, question two was are our clients giving us materials that AI created?
So this is something that is coming up a lot, especially for people, not solely, but especially for people in creative industries. So where they're taking materials, let's say, for example, someone who works in web design or graphic design, and they're taking elements to create a brand for a business, and they might not realize that they're using AI generated elements that have come from the client. Now, the issue there is very much an intellectual property one, and I don't want to go down, legislation rabbit holes because no one came for that. But it's really about what will you own if you're giving someone AI generated material, which might not necessarily have any IP rights, and they're creating something from that. Will you actually own your logo? And would you be able to trademark that? So these are really practical implications that are coming into our businesses and how we work without properly being aware of them. If we jump onto ChatGPT or Claude and we get it to mock up a logo for us or a design of our brand name, and we then pass that to a designer and say, we want this particular font and we want these particular design elements, not realizing that we might not then be able to protect it going forward. So I think again, a lot of this is going to circle back to that transparency. It's not again about demonizing the use of AI, but it's being open about the people we work with, so they then know how they can use the materials and make sure that we're protected.
So, we could be asking our clients, was this material created by AI, or just so I know, just so that I can provide you with the best thing, that kind of statement.
Yeah, absolutely. So a lot of the people that I'm working with, we're putting that into their contract that clients, when they share materials with us or source documents with us, to just let us know that some of it may be AI generated so that we can then do our work with all the knowledge rather than we doing it thinking we're dealing with client information and we're actually dealing with AI generated information.
Which actually feels like, because sometimes a contract, I know you're a lawyer, so a contract is important, but this actually feels like really important stuff for a contract, especially if you're a designer, like the example you just gave, where like they could come unstuck further down the line and then pin it on you, and you can say no because actually I'm pinning it on you because it was there to begin with. We had hopefully we work nicer than that, and we can say we had a discussion about this at the beginning, but it is in 4.2 that Ingrid made for me.
That's exactly it. It's obviously avoiding any arguments or disagreements, but it is again drawing our clients' attention to things. And it's because a lot of us aren't thinking about this yet. Again, it's not to make it seem like people are trying to do anything sneaky. It's nothing to do with that. It's really that we're using this tool so much in our businesses. And and again, I don't expect anyone to think about the legalities because they're not the most exciting part, but they really do have legal impacts for our businesses. So it's about having honest conversations with our clients and having it in our contract so that we're not left liable just in case something goes wrong.
Okay. Afternoon, how you doing? Or morning if you're in another part of the world. We've got Ingrid Fernandez with us. Ingrid is a lawyer, and we're having this chat with the Beam Freelance community, but broader across LinkedIn as well. So if you're not in the community, but hey, Anthony, for example, who's joined us, Anthony's got a question which I'm going to save up most of the questions to the end, I think, because we've got 5 points that we're going to be going through if you've just joined us. We've gone through the first 2. The others are on the screen right now, but really it's thinking about how maybe our use of AI is accidentally tripping us up legally and how we can protect ourselves with that. So number 3 is, are we using AI in our services for our clients?
So, this is an important one because a lot of us might be using AI in our businesses in different ways and not really realizing what that implication is for our clients and our customers. So, for example, a lot of us might be using it for ideating, brainstorming as kind of like a sparring partner. And again, I'm not saying any of this is bad or good or wrong or right. It's just about recognizing where you're using it and what you're using it for, and then noticing if any of the deliverables that you provide to your client or the end services that you provide to them have been created without your input, and whether it's just an AI agent generating that output. This is a really important consideration in terms of what the client is getting, because one, obviously we know that AI makes mistakes and it hallucinates and it makes things up, so from a factual perspective it's really problematic, but it's also because we can't always see how AI gets to those answers. We don't know the process it went through. It might be relying on information that we didn't give it, that it's sourced from somewhere else. So, one of the reputational risks really is that we don't know where these outputs are coming from. We don't know where these deliverables are coming from. So, where we're trusting AI to do parts of the work that we would usually do, we just run the risk of it not being something that we would put out into the world or that we would accept money for to do for someone. So it's noticing, I think, where AI can be a really valuable tool for you and your business, and balancing that against the risk that it runs if, I can understand that when people get really busy and things are very hectic, it might seem easier to trust AI to do part of your work for you. But if that's something that's client facing, we really need to consider the risks that that's going to run for us and for the client as well.
So this is more a thing for us to mull over, or is it also something that should be in our contracts? I suppose it's back to that transparency again, as to saying, hey, I'm in some instances I use this, and maybe explaining why, because it makes it more efficient so that I can provide X, Y, Z. But I don't know, what should we be doing?
Absolutely have it in your contract. One, it's the transparency that, keeps popping up as we chat. But another part is to protect you, because if people have that transparency about how you're using AI in relation to the services and products that you provide to them, they're more likely to engage with you honestly, knowing that you've used it as a brainstorming tool, or you've used it to synthesize a lot of information so that you can then provide them with the deliverables. Whereas when it's hidden, I think especially now where we're in, what people are calling a low trust era, if we're getting things from people that perhaps sound different to how they sound when you talk to them, and you might think, oh, that doesn't seem like the Steve that I had a chat with, or that doesn't seem like Steve on the podcast, this is a really different output. It really breaks that trust with our customers and clients. So if we can be honest and open with them and say, yeah, I use this for some part of the services, but everything I give you at the end of the day has my fingerprints all over it. Everything goes through me before it comes to you. It just reestablishes that trust, and having that in the contract gives the client the peace of mind that it's you that actually engaging rather than Claude.
Yeah. You see, this is why I like to miss deadlines sometimes, Ingrid, because it's that human element, do you know?
Yeah, yeah, it
Um,
just makes you so much more human to everyone when you are not where you're meant to be.
I'm joking, of course. I love to hit a deadline. Okay, so we've got Ingrid Fernandez with us. By the way, if you want to check out Ingrid online, obviously follow her here on LinkedIn, but herlegals.com is the website. So we're working our way through 5 things that Ingrid was trying to get us to think about in the way we currently run our freelance businesses, the way we're incorporating AI into it, and how that could be tripping us up. And the 4th one is, are our clients putting our deliverables into AI?
So this is the one that I think would probably be at front of most people's minds. This is what is occurring to most of it. So the other things are things maybe we need to think about, but I know this one is worrying a lot of people. So if we go back to the designer example I gave before, if a designer is producing a brand and a logo and beautiful design elements for a client, and then the client feeds that into AI to make derivatives of that they can then use on social media, or that they can then use on a flyer. There are so many unintended implications. One, for the designer's business, and obviously we're all aware that AI may be taking people's work and people's jobs. But the other part of it is the real creativity element. At the end of the day, we're humans working with humans, and humans trusting humans, in these transactions that we have for our businesses. And I think when our work that we put our effort and our expertise into is taken and put into something where other things can be spat out without the human part of it, I think that really risks not just our jobs and our work, but the human relationships and interactions we have by doing business with each other. Because could you just have a robot creating the design element and then sending it to a person who puts it into their robot, who then sends feedback to the first robot? At what point do we stop having humans in the loop at all if we're just going to use these robots for feedback and for interactions and to ask questions and to draft emails? It's not, again, I sound a bit anti AI, and I'm not anti using it, but I am anti removing the human from the loop in it.
And how can this trip us up legally? So it feels like there's a moral there's the moral side of it.
Yeah,
But if I mean, does it come down to the contract again? So if I'm an illustrator and I've created some characters for a client, but then they've taken those characters and they've fed them into an AI video generator and started creating a video, yeah, is that where this becomes an issue? Because I could have, maybe as the illustrator, I could have animated those characters, or you're now, it's a bit like if you were to put those characters, like in the past, the contract might have said you can't put these on a t-shirt and sell them, for example, without paying
yes.
me extra, that sort of license. So is that where we're looking at issues here?
Yeah, absolutely. Thanks for bringing me back to the legal. I go off on my ethical rants, but It is it's definitely a legal issue because it's our intellectual property. What we create, we either own the rights to, or we assign the rights to, or we license the rights to. Whatever we choose to do, we still own the rights. And as soon as we hand those rights to someone who puts them into a robot, we then lose control of what happens to our work. And so when these robots are then creating derivative works or creating alternative works, one that we could have used, or two, using them in ways that perhaps are not covered by our contract and are not part of the agreement we made with our client, that again puts our businesses at risks, because if our designs are out in the world for things that we would not have agreed to, that again reflects badly on us and our businesses. That might not have been a client you would have signed up if you understood what they were going to use those designs for, or in those particular ways. So it definitely has a very real legal implication. And yes, your contract is the first point of call, because this is this is really where we can have our biggest protections in place, is in our contracts. And as much as we want to have relationships and conversations, but our contract is where it sits if something goes wrong. We want to have a mechanism where we can take action if something happens. We don't just want to be stuck with the bad feelings or the resentment. We want to be able to do something. And that's where having this in your contract and restricting people from using your work in that way, that's where it can give a business the best protection.
And I wonder whether, is there a blurred line where, for example, a designer could give branding guidelines and everything to a client, and then that client puts it into Canva, and then Canva AI, and or could be other AIs available, all doing the same thing. Could be Adobe, right? But my thinking is that how is that different to them giving the brand guidelines to a different designer and paying a different designer to go off? As in, where does the job finish? You've created the brand guidelines, now the client can go away and create whatever they want with those brand guidelines. Or is it simply about defining that in the relationship and in the
Yeah,
contract?
definitely. It depends on where you land. So there are going to be some people who want to restrict what people can do going forward, and your contract can do that for you. And there are going to be other people who just worry about what happens in that relationship. And then once the relationship's done, they're happy for you to go do whatever you like. And that can be in your contract. So this is the benefit of having a contract that works for your business, because you can make it do what you want. Obviously, we're working within the law, but when it comes to your IP, you can be as strict or as flexible as you want to be. But if you're not thinking about it, and if your contract is silent on it, then you can't do anything. You relinquish your right. So it's really about thinking about this and then putting it into your contract in a way that gives you the powers that you want to have, and no more than that, just as far as you want to take it.
Yes, yeah. Because I'm a freelance podcast editor and video editor, so I make a lot of video podcasts for people. And I always kind of feel like, well, you've hired me to make that video podcast. I give you that video. And then I don't really care if you want to feed it into your own AI thing of choice to make the clips, to sort of cut things up. Even though you could pay me to do that, it's you can go do that. It won't be as good as if I did it, but you can go do that. But should I maybe be warning my client that, they're about to put the guest of that podcast into an AI thing? Like,
Yes.
even if it's just showing them what a professional I am, even if they then go and do it anyway.
Yeah. Again, we can't, as much as we can have contracts in place to minimize what people do without work, we can't control people in their business and what they're going to do. So, like you say, they might take the information you've given them and then go do what they're going to do anyway. But it comes back to that transparency. So, if you know that they're going to do that, and if you communicate that to the podcast guest, and they might have feelings about it. So again, it's just giving everyone that say, having the documents in place so that if you want to take a particular position, your contract supports you doing that. But then using that as a springboard to have the conversations, to be transparent, recognizing that people are going to do what they want to do anyway, but here are the legal implications that you're trying to minimize for your business.
Okay. Our fifth one was, do we have confidential confidentiality obligations. So basically, confidentiality obligations that restrict what we can put into AI.
So there can, depending on what your contract says and the different contracts you have with different people. So your client contracts might say something. If you work with other suppliers, they may say something else. So this is a good reminder to go have a look at your contract. But the confidentiality clauses in a lot of contracts that we're seeing now have specific limitations on sharing any business information that's considered confidential that comes up during your client relationship, restrictions from putting any of that into AI. So we used to have quite standard confidentiality clauses. Obviously, some were a bit more bespoke than others, but they tended to say the same things. But we're really seeing now a lot more confidentiality clauses are being strict about AI specifically. So if you were to enter into a contract with someone and didn't really check the confidentiality clause, and then you put some of the materials they gave you into AI to do some brainstorming or to do some of the background thinking work, you might be in breach of your contract. And then, there are legal repercussions you could be facing. So it's just another area of the contracts that, one, we need to look at in terms of the contracts we're signing. And then in terms of the contracts we're giving out to our clients, do we want to restrict our business information being put into AI? Do we want the confidentiality clauses to name that AI shouldn't see any of our business information? So we need to think again about what lines in the sand we want to draw in our contracts.
Flipping heck. What if I was handed, what if I had client information and I redacted the client's name from it and then brainstormed using, ChatGPT, Claude?
So it's going to depend on what the confidentiality clause says. So their name is personal information, but if it's, let's say, information about their business. So let's say they've come to you to produce their podcast and they've sent you some information about their current financial situation in terms of sponsorship that they're getting or in terms of the amount of listeners they have per month or whatever it may be. And you then feed that into AI. That for them might be considered, or according to the contract, that might be confidential information. So even though you've redacted their name, the body of the information might still be confidential, and you might be breaching what the contract says by feeding that into AI, even if it's just for you to be able to think and process and brainstorm. So it's not necessarily just the personal information, it's also what else we're sharing.
Okay. So I'm imagining I'm watching this and thinking, well, a bit like Kerry has just written on LinkedIn. Hey, Kerry, she's written, feels like a minefield. It's a polite way of saying what I was thinking. Is how do we go about this? Because we are companies of one, so we need to think about. It feels like we need to sit and think about how we feel about this, but then also think about how we want this in our contracts, what we might get from client contracts. Like, what's the step? How do we navigate that minefield, as it were?
Yeah, absolutely. And I'm so sorry, Kerry. This isn't meant to be overwhelming, but it is a little bit of a minefield because we're dealing with this new tool. And when I say new, I know it's been around a few years, but it's new to the business space. And we're seeing it in our businesses in ways that, the law wasn't necessarily designed for. So we're kind of working in a way that we think is best with the laws that we have. So the first step is definitely to have a think before we'll come to the action step in a second, but I'd really get people to just think about this stuff, how you feel about your information going into AI. If it doesn't bother you, great. If it does bother you, then you need to think about what that means for your contracts. And then think about how you use AI in your business. And again, there's no right or wrong here, but how you're using it in the best ways, how your clients may feel about the way you use it, how transparent are you being in how you use it. And then once you have your head around what you want that to look like, you can definitely get legal advice about protecting yourself and protecting your business, protecting yourself in your contracts, because the first step is really to understand where you stand and then get your legal documents to support that, because they're really there to support your business. They're not there to be a blocker or to make things more complex. It's the opposite. Your contract should actually make all of this more simple, because then you're not thinking about it each time. It's just there on a piece of paper, you send it out and you're done. You don't have to worry about it each instance.
Such a good point. Okay, so we can have a think about it, look at our contracts, talk to a lovely lawyer like Ingrid, who probably, let's be honest, is more than us, thinking and seeing lots of these different scenarios and therefore having to update stuff. It feels as well like some of this is probably like, I'm not demeaning your job, Ingrid,
No,
but it's probably like adding another sentence onto an existing thing. It's like this clause and the AI. I'm not saying I could write that sentence, but it feels like a lot of this is already there, but actually we're expanding the way our contract might already exist.
That's exactly it, Steve. This is not about tearing everything down and starting from scratch. It's really just refining things because of the tech that we're dealing with, protecting your business a little bit better because of the tech we're dealing with. So it's not at all an overhaul. It's really just tweaking what you already have to make sure you're as protected as you can be, you're as transparent as you want to be, and you're doing the best you can. That's really what it's about.
Kerry asks, where's the line on what info is classed as confidential? Do they have to tell you if something is considered confidential?
So that should be in the contract as well. So usually when there's a confidentiality clause, there's a definition of what's considered confidential. So that should all be hopefully within your contract. So it's crystal clear what is confidential and what's not.
Okay,
This
cool.
is why contracts are so handy. Everything's in them.
And what if though that comes at a stage before a contract? Because sometimes you have discussions with clients and you're sending stuff back and forth, brainstorming ideas. You might create a pitch for something. Like I know in some instances you might be asked to sign an NDA, but not always.
No, absolutely. There are a lot of times we're dealing with confidential information without having that contract in place. And what a rule of thumb that I tend to give people is deal with the confidential information you get how you would deal with your own confidential information. So it's really minimizing the risk for any confidential information or potentially confidential information. So anything about anyone else's business that you may come across or that comes into your possession or that you work with, treat it as confidential as you would treat your confidential information.
Nice. Oh, Ingrid, thank you so much. If you've joined us live today, though, and you wanted to ask a question, then now's a really good chance to do it. Pop it in the comments, and thank you for joining us live. We'll put a replay of this in the Being Freelance community. If you don't know what that is, it's full of lovely freelancers. Ingrid's one of them. You can go to beingfreelance.com. Click on community and you'll find us all in there, and it's got replays for Q&As and lots of other things that we do as well. Kerry says, I know what I'm going to be doing this afternoon. Yes. So the main things that we were talking about, especially if you joined a little bit later on, was starting with the privacy policy, which is most likely, hopefully, on your website already, which we should be updating, I think you said, with any new tools that we use anyway. So in this instance, the AI elements of those tools. So that doesn't necessarily mean we have to then outline, Google Meet's own terms and what they might do with it. It's simply saying, I use this tool.
That's right. Yeah.
Okay. David says, oh no, sorry, I've kind of cut myself off there. So yeah, privacy, and then moving on to thinking about how we want to be transparent about it, and therefore hoping our clients will be transparent with us about our use of AI. That's not really a legal thing, more just a sort of moral and doing nice business wise. And then in our contracts, how it will affect us doing business, but what our clients might also do with the work we create. So all of the things that are probably already in your contract, do they need to be expanded? Which is where a lawyer can come in handy to go, yes, and then put in the right wording. David says, using a tool like Granola for assisting with call notes for an initial call, i.e. before contract, is it sufficient to have a disclaimer in my general terms on my website that specifically states they can opt out of that? They just have to ask. Other note takers are available.
Yeah, absolutely. You can have that disclaimer in your terms. I would still mention it at the beginning of a call to give people, unless you've sent them a copy of those terms beforehand, they might not have come across them before. But I think it's about getting into the practice of asking people before they're participating in the tool. So at the beginning of the call, just letting people know that that's what you may use and they can opt out if they prefer. I think it just avoids any doubt, just in case they haven't seen any of the terms that you have or the disclaimers you have in place.
Yeah. Because AI transcription tools and note taking tools are so common, and like we were saying at the beginning of this, are so baked into things that we use anyway, let alone, going into generative or deeper generative AI minefields. Anthony was saying, Anthony is a voice artist, by the way, who says, in being transparent, should there not also be the onus, good word, Anthony, to understand exactly how any data collected is used? If, for instance, it's fed in any way into datasets for training, and this goes further with video conferencing or content that features visual or audio elements that might be fed into training systems. Obviously, as a voice actor, I'm not keen to allow my voice to be recorded by AI-driven systems, and I'd be surprised if most users of these tools know what can and cannot happen to the raw data collected.
Yeah, so this is a big part of, we don't really understand the full extent when we hand any information into AI in any format, let alone personal information. We just don't know what's happening to it. So there are things we can opt out of in terms of it being used to train AI and so on. But again, we're very limited in terms of, because of that opacity, we can do what we can, and we can obviously be as transparent as we're able, and we can read the documentation made available to us. But at the end of the day, we can only work with what we know. So limiting the information that we feed into AI, or other people's information that we feed into AI, I think that's a really pragmatic way forward, because we just can't see what's happening behind the curtain.
Yes. Kate says, thanks very much for this. Loads to think about and super helpful. Glad I stumbled across your chat while procrastinating about something else. Kate, we are happy to be procrasti-thinkers with you this afternoon. Ingrid, thank you so much. If you've got a last-minute question, pop it in the chat. But if you want to catch up with Ingrid, she is herlegals.com. That's the website, though, of course, you'll find her on LinkedIn and on Instagram. And I'm sure we'll be happy to have a look or help you think about how you might put this into your contracts or privacy policies. And what's the other one as well as a privacy policy that goes on your website? Is there another one?
Your cookie policy?
Oh, I love a cookie policy.
I knew you'd like that one.
Yeah. Okay, then, do catch up with Ingrid as well. But for now, thank you so much. If you want to come join us in the Being Freelance community, that's where this replay will live on as well. But it's full of lovely freelancers. It'd be awesome to see you in there. And we also, if you've stumbled across this and you don't know what Being Freelance is, go to beingfreelance.com, because there's loads of podcasts that I've been doing for the last 11 years that you can listen back to, which all transcribed on there as well. Though maybe I should have asked people's permission. Oh, it's a minefield. No, it's all good. Ingrid, thank you so much. Did we cover everything, by the way? I know there's probably more. We limited it to 5 things in case our heads blew off. But did we? It was mainly transparency and thinking about it and getting it in your contract so that you're not just protected, but it just makes things simpler as well. Once it's in there, you can stop thinking about it and worrying about it.
Yeah, absolutely. It's just one of those things we want to sort as much as we can so we can get on with running our businesses and not have to think about it.
Brilliant. Um, Ingrid, thank you so much. See you soon. Everybody else, thank you for joining us. Suze, as deal with whatever that word was. Transcription tools, I dare you. Even I don't know what it said. See you soon, guys. Take care. Bye.
Bye.